My name's Ken Robertson. I'm a trust and estate practitioner. One of the things that people ask me about is estate planning. And what is estate planning? Estate planning is that orderly transfer of assets that have been accumulated over a person's lifetime to the people that they want those assets to go to the beneficiaries of their estate. The first part of estate planning is, what is wealth? So one of the things that we're looking at with wealth are the assets that have been accumulated over a long period of time by a family. And one of the things that we need to consider when we're looking at the estate planning side of things is it's the individually owned assets that we are going to be transferring from one generation to the next generation. A lot of clients get confused between the sorts of assets that they can transfer. One of the things that they believe is that assets that belong to their trust or their company are assets that they can transfer in their will. That is not the case. It's only the assets that they own individually that can be transferred using the wills. Jointly held assets can be held in two ways. They can be held as tenants in common or as joint tenants. Now, there is a difference when we're doing estate planning between the two, because assets held as tenants in common can be left in your will so that the beneficiary gets to get the asset that you've held jointly with somebody else. So that part of it we can put into a will so that the estate then gets those assets to distribute to the beneficiaries. Where we've got assets being held at joint tenancy, one of the problems that we've got there is that as soon as one of those joint owners dies, the asset devolves to the surviving partner. Now, for instance, the family home is often held in joint names, and that, generally speaking, is joint tenancy. So what happens there is, as soon as one of the partners dies, the asset immediately goes to the surviving spouse or other owner. So it's quite important to determine whether or not we've got an asset being held as tenants in common or as joint tenants. Estate planning can be quite complex. One of the things that we try to do with estate planning is to make sure that the beneficiaries who you want your assets to go to do actually end up in their hands. One of the most important things whenever we're doing any estate planning is to ensure that you don't create another beneficiary that you weren't planning on, like the tax department. So it's really important with estate planning to make sure that you get the tax side of it right. Otherwise, we end up making the ATO a beneficiary of your estate. Another thing to consider with estate planning is that a lot of times we're pressured to forgive loans that we have with our family companies or our trusts. And in forgiving a loan that you have lent to the family trust or to the company, and that usually happens when you're setting these companies or trusts up, you have to inject funds so that these trusts or companies have got some funds to work with. Debt forgiveness of those loans is a definite no-no. We don't do that for the simple reason that we turn a non-assessable source of funds into a taxable source of funds, because the only way to get money out of a company, for instance, if you don't repay that loan and you forgive it, is for that company to pay a dividend. And that dividend is an assessable dividend to the person who's receiving the dividend. So what I generally try to do is, if we're leaving shares in the company to a particular beneficiary or a number of beneficiaries in a proportion, what we do is we do the same thing with the debt that's owed to the person who's died. Another tip I have is it's very important that we get a family meeting prior to the deceased dying. We need to have that family meeting so that the beneficiaries understand what it is that the will maker is trying to achieve. We don't want to end up in a situation where they find out about it after the will is read, because then there can be quite a bit of angst between the beneficiaries, and we don't want to have that sort of situation. One of the things that I'm seeing at the moment is there has been a lot of increased litigation around estates. We're seeing these family provision applications where beneficiaries feel that they're not being looked after properly. So what I'm suggesting here is that we need to be so careful about what we do when we're putting together an estate plan for a client that we don't end up in court in 10 or 20 years' time, and that's when it's going to happen. It's not going to happen tomorrow or the next day, unless of course that person dies tomorrow or the next day. It's generally going to be 10 or 20 years' time. And we don't want to be in a situation where we're introducing another beneficiary to the estate, and that's a number of lawyers fighting over whether or not it's a fair will and the beneficiaries have been treated fairly under the will. So to avoid the situation where you end up with these unexpected beneficiaries, like the ATO or some lawyers fighting over family provision applications, it's so important that you seek out the professionals that do understand and have got a lot of experience in the estate planning field.